this court has consistently taken the side of corruption against every device that Congress has created to try to fight back political corruption. And if you think about it, the very same people that captured this court, the very same powerful special interests that used, $600 million, I think Lisa's calculated, in dark money to put together the scheme to capture this court, they're the ones who benefit when you unleash corruption. Because now you're not really doing democracy anymore. Now you're doing oligarchy. Now you're doing billionaireocracy, because they're the ones who can put the big money out there.
Welcome to a special edition of Legal AF. The United States Supreme Court has been back since October holding oral arguments. But this past week, there are two tremendous, historic, landmark decisions that are going to be coming off of two oral arguments that our audience needs to know about and follow more closely. One involves campaign finance and the ability of a campaign to coordinate its efforts and its fundraising with political action committees. It's one of the last barriers that protects our democracy. Is it about to fall? We just had oral argument, and we're going to talk about that. And there's a case involving Rebecca Slaughter and the Federal Trade Commission. And this is one of several cases that the United States Supreme Court wants to hold oral argument over and issue an opinion about the executive branch's power to fire effectively at will members of boards and agencies created by Congress, those that Congress wanted them to be bipartisan, wanted them to be independent, wanted them to be quasi-legislative. But what's the Supreme Court going to do about it with a 95-year-old precedent called Humphrey's Executor? I can't think of better people to talk about this with our audience with than Senator Sheldon Whitehouse and, of course, Lisa Graves of Court Accountability Action. Welcome to you both.
Thank you. Great to be with you.
Yeah. And this is stuff at Senator Whitehouse that our audience is focused on, but I'm not sure even in a way that they should be about. I don't want to kick it off, as Lisa and I talked about it, about the campaign funding issues and coordination issues. You want to kind of brief our audience a bit about what's at stake and what just happened in the oral argument?
Well, I think key here in looking at both of these cases is to understand that both are corruption cases. The question of corruption is at the heart of both cases. The NRSC, National Republican Senate Committee case, is kind of the last gasp of campaign finance integrity after Citizens United did so much harm and caused so much corruption. So most of the damage there has already been done. And what's really notable about the FEC case, NRSC versus FEC, is that since Citizens United in 2010, it has been proven over and over and over again that Citizens United was wrongly decided. That the premise of that decision, that all the unlimited money they unleashed was going to be what they called transparent, subject to effective disclosure, so that voters and citizens would know who was behind the crap coming out of their television or through their internet feed. And of course, that is just like indisputably, flagrantly, flamboyantly false. And billions of dollars in dark money have indisputably proven. And yet here we are 15 years later, and the Supreme Court sits on that decision as if it were still real, as if it were still good law, even though the premise that it hung on has now been totally exploded. And what was telling about this to me is that in the argument, the question that the fundamental proposition here is one of corruption, and that the baseline off of which these decisions are drawn, the Citizens United baseline, is a false baseline. So that's, what you'd hope is that they'd go back and a legit court would reconsider Citizens United, would confess its error, and would go back and look at how you reanalyze that case in the light of the corrected error. Slaughter, now you're looking forward at corruption. You're looking at getting rid of Congress's ability to set term limits for agencies, which means that all the power over those agencies goes straight to the Oval Office. And you set up a situation where the big donors who have big decisions in front of regulatory agencies can go to the Oval Office, can make the big promises, pay the big bribes, get all that wonderful presidential immunity animated by having the president do crimes for them, and get that message down to the regulatory agency that here's what you're supposed to do. And that's a completely different model of regulation than we've trusted for our entire lifetime since Humphrey's executor. And it's a gateway to corruption. So I'll end where I began. These are both corruption cases, and the Supreme Court in both cases is headed in the direction of enabling corruption.
So, Lisa, you've written a great new book called Unprecedented about the Roberts Court. You got to hear these two oral arguments, as Senator Whitehouse put it, about corruption in the past, in the back, and in the forward going forward. What did you make of? First of all, why are we back talking about the coordination between campaign and political action committee? I thought that was already settled law from a 5-4 decision 10 or 15 years ago. Other than the fact that they now have the numbers, why are we back on this issue?
Well, that's exactly right. What we've seen since the immunity decision last summer, where John Roberts orchestrated the unprecedented grant of immunity from criminal prosecution for Donald Trump, is that, in essence, the mask has fallen. They're going full speed ahead to aid Donald Trump and aid the Republican Party in its extreme agenda. And this case, it didn't need to be revisited. It's only being revisited because they presumably think they've got the numbers to destroy this last standing component of one of the main protections of federal campaign law against corruption. And as Senator Whitehouse pointed out, I mean, it really is about corruption. And this is long-standing corruption. And I do want to say, briefly on Citizens United, the fact is that decision was illegitimate from the outset because it was a 5-4 decision. It was re-argued basically to reach that result. It was a decision that Clarence Thomas sat on, even though his wife received a $500,000 gift to stake her in an organization to benefit, to use that ruling to come. And he knew it, and he sat on that case anyway. In my view, he should have recused himself. Should have been a 4-4 decision. The lower court's ruling should have stood. But the other part is, really thinking about John Roberts, it feels like he's trying to vindicate Richard Nixon over and over and over again. This continual assault on campaign finance limits, which are really about corruption. The law that the Federal Election Campaign Act replaced was the federal anti-corruption law expressly. But sometimes lawyers at the court don't talk about it as corruption. Senator Whitehouse is exactly right. This is all about corruption and trying to contain corruption. And what this court is doing is unlocking it, unleashing it, and empowering it further. And the Slaughter case, as the senator points out, is exactly about that. The kind of shakedowns we've already seen in some ways with the mergers, with the role of the FCC, for example. This would basically eliminate the last remaining limits on the presidential ability to basically stack those commissions with quacks and hacks and loyalists whose only vision is to do his bidding. And his bidding, as we can see, is actually bidding, meaning who is going to pay to get the results they want.
Judge Breyer today, in an order, Charles Breyer today, in an order kicking the National Guard, or at least the federalized National Guard, out of California, said in the beginning, and I'm paraphrasing, of his order, the founding fathers and the framers envisioned a system of checks and balance. This administration sees it as only a blank check in their favor, and that's right. And that's what we're watching, right? He's going to use the Department of Justice's antitrust division to interfere with commercial transactions, like who gets to own CNN, his buddies or Netflix. He's
Right.
going to use Brendan Carr at the FCC to do his bidding. He's going, we just saw what happened with Elon Musk and Doge, with the oil industry and the rest. And the thing that we always relied on was the Congress and their ability. Yes, it's an executive agency or regulatory body, but that it has legislative or quasi-judicial components to it. And now, based on what I heard at the Rebecca Slaughter oral argument, say goodbye to Humphrey's executor. And now, if it doesn't matter what Congress's intent was under this unitary executive model, which was created out of whole cloth effectively by Robert Bork and then carried on to today, whatever the one person occupant of that branch wants to do, as long as it's an executive branch function, that they're going to be able to do. I mean, there's no stopping him now based on the Slaughter oral argument. Is there, Senator Whitehouse?
Well, you've got to, I think, recognize that not only were the founders extremely interested in checks and balances and setting the three powers somewhat against each other so that each would be the rival to and the check on the other, but they were desperately concerned about corruption. Mm-hmm. The word corruption comes up over and over and over again in the Federalist Papers and in the debates as the Constitution was put together and in the literature of that period. And it meant quid pro quo corruption, the narrow slice that the Supreme Court has left that can be prosecuted. But it also meant just dis-ease, unhealthiness in the body politic, that like the corruption of the blood sort of thing. And this court has consistently taken the side of corruption against every device that Congress has created to try to fight back political corruption. And if you think about it, the very same people that captured this court, the very same powerful special interests that used, $600 million, I think Lisa's calculated in dark money to put together the scheme to capture this court. They're the ones who benefit when you unleash corruption, because now you're not really doing democracy anymore. Now you're doing oligarchy. Now you're doing billionaireocracy, because they're the ones who can put the big money out there. So when this court continues to knock down the guardrails against government corruption, you got to look at who's in the back room, who's filing the amicus briefs. In the NRSC case, there were 25 phony baloney amici in the flotilla of amici that they sent in to tell the court what to do. And they're all funded by the Koch brothers, by MAGA, by Donors Trust, by the same elite right-wing freak show that for years has now successfully managed the effort to capture the court.
I mean, Mark Elias, who argued on behalf of the Democratic senators and others in opposition, he said there's nobody in this room, no one in this room that knows the database better than me. And I can tell you that I can't find the needle in the haystack, and the average American couldn't either. So to your point, Senator Whitehouse, about, if we just make everything transparent, that'll do it. No, because even artificial intelligence can't keep up with the volume of data and the connective tissue between all of these entities and the various people.
Except that if you actually made those campaign donations transparent, the way the Citizens United Republicans promised it would be, then a lot of this nonsense would go away, because you could still spend tons of money, but at least citizens would know who was spending the money. They could identify what their motive was, and they could discount them for being bad players, being up to no good and creating mischief. And frankly, if Exxon were running ads against me in Rhode Island saying Sheldon Whitehouse is our enemy, he's a bad guy, keep running it, man. I love that. But Rhode Islanders will vote for me all day long if they know it's Exxon. But when it's Rhode Islanders for peace and puppies and prosperity that comes through a mail drop in some other state, and you get all this junk, tsunami of slime across the TV and internet into your thing, that's a whole different model of citizenship. And regrettably, the Roberts Court is behind that corruptible model of citizenship rather than the responsible democratic model.
Let's stay in the FEC case for one more time with Lisa. What did you make of the fact that between Gorsuch and Amy Coney Barrett, one question was asked? and there was just utter silence from them. What do you think that means?
Well, I don't read the tea leaves very often in terms of the questions, but that was perhaps telling. I mean, I think part of what's happening here is that we have an expectation that is no longer a valid expectation. And that expectation is that these justices are keeping an open mind or have an open mind, and that they are persuadable. I think what we've seen from the reality is that this court has been stacked. As Senator Whitehouse wrote in his book about court capture, it has been captured, and deliberately so. Every one of the justices on that court, other than Clarence Thomas, were chosen as part of a No More Suitors campaign. They didn't want judges on the court who would be fair and open-minded and follow past precedent. They were chosen because they were thought to be gunners, ringers, and Thomas was already a ringer. And when you look at what's happening at the court, you have this performance in a way. And I don't want to denigrate it too much, because I really appreciated Mark Elias's arguments, and I appreciated the efforts of the justices Sotomayor and Kagan and KVJ to question, to really try to have the American people understand what's at stake. But the Republican appointees, in my view, are really engaging in a bit of theater, as if this is really an open question. What you have is a court that has been stacked to move this extreme agenda forward, including this, as you point out, this extreme theory on unitary executive theory, which would imbue Trump with even more king-like powers beyond the king-like powers this court has created for him over the past year in these emergency rulings, as well as that immunity decision. But also, you have a court that is hearing from amicus briefs, and Senator Whitehouse has an excellent cure response to that in a piece of legislation to address it. But you have this amicus brief that's like throwing the voices of these billionaires, throwing the voices of Koch and Leo and these others. So it's like Koch, Leo, but you can't see it. It looks like the Center for this and the Institute for that.
Ventriloquism, when you say throwing the voices, right?
Yeah, it's been and so
ventriloquism,
right?
Yeah, so it's this. There's a theater happening, and in reality, what's happened, in my personal view, is that there's a racket where now these cases are being brought up to the court with results that are almost certain, because the court isn't behaving like a fair court, like an impartial court. It's behaving like an arm of the Republican Party.
Yeah.
And of these billionaires who are really the ones backing the extreme agenda of this party.
Because what would be the legitimate good faith rationale, just to catch our audience up a bit, in stopping the coordination between the party and the Political Action Committee? And so the people understand, if this thing fails and falls, which I think, believe it will, based on at least the oral argument. It's hard to read tea leaves, but I think it will. If it does, that means that the campaign for Donald Trump or whoever can have a phone call on a daily basis with the Political Action Committee and says, how much money do you have? Okay, so we're going to buy the billboards, and you're going to buy that, and this is our messaging over here, and you're going to be over, and that's going to be your messaging over there, and we're all coordinated, right? Okay, gang, break. As opposed to what happens now, which is at least some semblance that it's not just, then you know what? If you're not going to have, then why do we need political action committees? Then just have unlimited funding directly to the campain.
Well, and beyond
I don't understand
that,
the role of the Political Action Committee then, if you're not going to have the coordination barrier.
Well, I mean, they've been drawing down that barrier for some time. And one of the premises of that, what I call the Billionaires United, the Citizens United ruling, is that one of the premises of Justice Kennedy was there wouldn't be coordination, that this outside spending would be of very little value because it couldn't be coordinated. Right. And so the campaign didn't control it. And so it really didn't count as corruption. And it didn't meet, as Senator Whitehouse said, that very narrow quid pro quo corruption, which, by the way, the court is also decimated with after the fact, gifts and tips. But let's just keep that assumption in mind that, you can't have this thing of enormous value happening in the dark because they said it wasn't very valuable for outside groups to run attack ads. The reality is that those attack ads, the campaigns want those attack ads to be run by those other groups so they can keep their hands off it. Exxon, doesn't want its name on an ad attacking someone on climate. It wants a front group. They all want a front group. And so this would enable this so much further. And at a moment where we're seeing this explosion of AI also entering the political debate, the consequences of disinformation running even more rampant because of this Supreme Court, it will further harm our democracy, our republic, the ability of people to understand what's really happening and to be, have real agency in our democracy. And that's not all the court is doing, because then we should talk separately about what's happening on voting rights. But the fact is that the Roberts Court is singularly destructive of the voting rights, of the rights of the American people, their interests against corruption, and they are standing against, as Senator Whitehouse noted, the weight of history and our founding against corruption.
So let me ask Senator Whitehouse something, because our audience is concerned about these things. Suppose in a world not too far away, there is a democratically controlled House and Senate. What in that world, and maybe even with a president that's also a Democrat, what in that world can the House and the Senate do to fix some of the mess that we've identified at the United States Supreme Court when it comes to, let's stay with campaign finance?
Well, the single most important thing that can be done to push corruption back more into the shadows where it belongs would be to pass the Disclose Act, which is clearly authorized by the Citizens United decision. And it basically says, if you're spending more than 10 grand in a political race, you've got to out yourself for who you are. And you can't launder your money through a 501c4 and into a super PAC, or through a shell corporation into a 501c4 into a super PAC. Those games are over. And now citizens can make a real judgment about what's happening around them. And over at the court, you need to give it a real ethics code, one where there's actual fact finding that's done, so that Clarence Thomas can't get away with pretending that there's no there when Leonard Leo sends $500,000 to his wife, betting on the outcome of a case that he's about to decide that will enable her to spend the $500,000 in the way that the new case will allow. And then you got to do term limits. And the way I would do them is retroactively, so that if you've been on the court 18 years, we start moving you off. You go into senior status. You can take the constitutional cases. There are rare ones, but the Constitution says there are certain cases the Supreme Court must take. Okay, you go do those. And the 9 justices that are now refreshed and renewed take on the 95% of the court's business, which is the appellate jurisdiction, which Congress gave to it. The Constitution didn't say the Supreme Court gets to decide appellate cases. Congress said that.
Now you're just being accurate. Because I've always said to the originalist textualists, show me in the text of the Constitution the power of the United States Supreme Court to declare what is constitutional or not and have it be binding. Oh, wait, that's Marbury versus Madison, right? That's Chief Justice Marshall.
Yep.
Yeah.
And even there, the lesson of Marbury versus Madison, it is emphatically the province of the court to say what the law is. And the sin of Citizens United was the court saying what the facts are, and getting the facts wrong, and either deliberately getting the facts wrong in the first place, or deliberately and stubbornly sticking to those false facts once they were indisputably proven to be false. So the whole question of the Supreme Court's authority in the Citizens United case depends on this new radical extension of the Supreme Court, that it gets to make up facts and then hang decisions on those false facts, and that nobody's going to notice because, Marbury versus Madison. No. Marbury versus Madison you got to say what the law is.
To your point, Senator Whitehouse, I think it was in the Kennedy prayer case with the high school coach that wanted to take the knee at midfield. Sam Alito, during oral argument, said a version of, let's not get bogged down in the facts in this case. Yeah. I was like, what? Let's not get bogged down. And now we're just the oracle of, we're just the oracle. We're just issuing, we don't even need cases. Why do we need cases?
They misstated the facts of the case so blatantly that in dissent, the dissenters put in photographs
Right, of the prayer, the
show-
mandatory
to
prayer.
show that what they're saying didn't happen. Yeah, there's actually a picture of it. Of course it happened.
Right.
Well, and that attack on the facts, this arrogance of the Roberts Court to assert that it can make its own facts, is part of what's animating this whole set of rulings on the emergency docket, including about Texas, setting aside days and days of trial testimony or testimony before the trial court, before the district court, about what was happening in Texas, and just deciding that doesn't matter. Just like John Roberts set aside tens of thousands of pages of finding by Congress on the necessity of the Voting Rights Act provisions, just disregarding them. In the South Carolina versus Alexander case, the one coming out of Nancy Mace's district, where they bleached out 20,000 Black voters, the Roberts Court is basically deciding that facts that the lower courts have found that are not erroneous, that in fact are well documented, don't matter because they're in the way of the law that this court wants to imagine and create and impose on us.
Lisa,
And
you're going to
starting
need
to see district judges get angrier and angrier about that lack of support and that blowback. And that's going to be interesting to watch because the court has never seen that before from lower courts.
Hundreds of judges have secretly spoken to the media about it as well. And to Lisa's point, Lisa, you're going to need a pocket part for your new book, just based on the last week or two. I mean, my eyes almost popped out of my head when, in the Texas case related to the voting maps, when they effectively said, you're not giving proper deference to the legislature. They had a letter from Harmeet Dillon at the Department of Justice effectively telling them to racially gerrymander. It was part of the record. And Kagan had the best line, which summarizes Lisa's point, I think, eloquently. She said, we may be a higher court, but we are not a better court when it comes to developing the record.
Yeah, exactly.
And
that is widely understood. There's a reason that factual development is done at the district court level where it can be challenged, subject to cross-examination, reviewed by the judge, reviewed on appeal. The idea that the facts in a case get made up in the private secret deliberations of the Supreme Court by 5 people who get to make up whatever facts they want that get them wherever they want to go. Supreme Court deliberations are the worst place in government to decide facts.
Yeah. Absolutely. Yeah. And on the legislative side, I mean, good luck to you, Senator, and your colleagues and in the House. You're going to have to develop, I guess, new types of, let's use the term poison pill or something to protect agencies and regulatory bodies from an out of control executive branch. I said to myself during a recent video, I said out loud during a recent video, I don't know who in their right mind would create an executive agency or board knowing what the new law is likely to be under this teardown of Humphrey's executor. But you guys are going to have to come up with a more creative way to check the out of control power of the president.
Yeah. Which is a corruption concern. That's the problem here. That's the worry. Expertise goes out the window and political influence replaces it.
Yeah.
And that's a prescription for government by corrupt special interest.
Well, let me end it this way, the way we started it with Senator Whitehouse's corruption prism. Why, this is for both of you, why is this MAGA 6 of the Supreme Court, why are they not concerned about corruption at the executive branch level? Why is this not a concern of theirs?
I'll go first, and then if you want the last word, Senator, I was thinking about the fact that John Roberts has aggrandized the court's power to make it, or at least to presume that it is without check in reality, because it's grounding its decisions in a constitutional doctrine, not in statutory interpretation necessarily, the narrowest grounds, but asserting over and over again what Congress cannot do. And in doing so, it is giving itself supreme power beyond just the name Supreme Court. And so I think John Roberts is pretty comfortable with unchecked power. He's wielding it quite devastatingly. And I also think they're operating under a fiction where they say they're not dealing with this president, they're dealing with, quote, the presidency.
Oh, right.
But, the abstract versus the reality. But this presidency, this particular presidency, is an illustration on a daily basis why unchecked power is so dangerous. And if they can't or won't see that, I think they have really, in effect, abdicated their responsibility to be the fair judges that they were confirmed to be on paper. And instead, they are abusing the power of the court in order to aid their party, and perhaps with the presumption that if they have fixed the elections the way it appears they're trying to, that they won't have to deal with a future Democratic presidency or Democratic Congress.
I mean, power. What's the old phrase? Power corrupts, and absolute power corrupts.
Power corrupts, and absolute power corrupts. Absolutely.
Absolutely, Senator Whitehouse. Why? Do you agree with Lisa?
I would say, for reasons that I can't explain, the right-wing justices, the Leonard Leo types on the Supreme Court, have for a long time exhibited a really abiding contempt for Congress. Congress finds facts after enormous effort, after public hearings, after all this. They discard it like it's just waste, and they come up with their own facts, and they have very little regard for the workings of Congress, and I can't explain that. It's supported, though, by, I think, they were selected for a tolerance for corruption by a right-wing apparatus that was deploying corruption to get its way. Yeah. After they failed to get Bork on the court, after they failed to get Stockman in the Reagan era to put through their anti-regulatory, anti-welfare state, they called it, proceedings, after they failed to get Republicans in Congress to pass the stuff that they wanted, after they catastrophically failed to get themselves elected. You know, there's a Koch brother who ran like 2% of the vote. So they failed and they failed and they failed and they failed. And they realized the only way we can do this is to follow that Powell memo strategy and take over this court and put people in there who will open the avenue of special interest corruption for us. So the prime loyalties of this court are to a cabal of billionaires who funded the jet trips, who took care of their expenses, who go to all the Federal Society dinners, who laud them and, cosset them. And it is that group that needs corruption in order to exert its power, because a true democracy would laugh them out of the conversation.
So they're I was just thinking, they're genetically engineered lab mice they're genetically engineered to not see or care about corruption, because the people that put them there are massive architects of corruption. Yeah. I'm so glad we got together today to talk about this with our audience here on Legal AF, Senator Sheldon Whitehouse of Rhode Island, but more importantly, of our democracy, who's out there every day working hard to protect our democracy, to reinstall the guardrails, to come up with new guardrails that have already been blown by, and to try to reinstall the friction between the co-equal branches of government that are supposed to be there to encourage our checks and balance system that our framers and founding fathers developed. Lisa, last word.
Just an honor to have you on this show again, Senator Whitehouse. Thank you for all that you're doing. You are a real hero, and it's been great to have this conversation with both of you, and hope we'll have more to come.
We will. And thank you again. Michael Popak, Lisa Grave, joined by Senator Sheldon Whitehouse here on Legal AF. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.